you please call the case?
Good morning. Our first case this morning is the appeal of Carl L. Giordano, case number 18053180.
Thank you. Good morning. Welcome. Thank you for coming. We're going to start by handling a few things off the record. That's just to ensure a clean and efficient hearing. It'll be procedural stuff, clarifications. And off the record just means that it's not going to be in the transcript when we're deciding the opinion later. Afterwards, we'll go on the record, and I'll stop for questions before we go on the record from the parties. We'll do formal introductions on the record, but I want to first make sure that everyone's here and present. The panel members are here, stenographer is here. And appellant, did you have anyone else coming with you today, or is it just yourself?
Myself.
Okay. And Franchise Tax Board, is everyone here for you?
Yes.
All right, thank you. The first matter I wanted to cover before we go on the record is the issue on appeal. And I know after the conference, the minutes and orders were sent out, and it clarified that we will be discussing whether appellant has shown reasonable cause for the failure to respond to the demand notice. I also wanted to add sort of a preliminary part to that issue of whether a demand penalty was properly imposed. And this will incorporate some of the arguments made on appeal as well as additional briefing requests, such as appellant's argument that he did in fact timely respond, the question of whether, if there was such timely response, was in the manner prescribed, and also the question of whether the regulatory requirements were satisfied. Do the parties understand, are any questions regarding adding to the issue whether a demand penalty was properly imposed to Franchise Tax Board?
No, I do not have any questions.
Any appellants, does that make sense?
No, I do not.
All right, thank you. The second issue is exhibits. I know we have exhibits 1 and 2 from appellant and exhibits A through I for Franchise Tax Board. Appellant, did you bring any additional exhibits today?
I did not.
Okay. And Franchise Tax Board, any new exhibits?
No.
Thank you. And I believe from the conference there were no objections to the exhibits. Is that still true, appellant?
Yes.
And Franchise Tax Board? Okay.
Correct.
I'll introduce the evidence without objection once we go on the record. And the last matter is the order and timing. And this is basically going to be the same from what the minutes and orders laid out. We'll start with appellant. We'll swear you in. You have 5 to 10 minutes to present your testimony and arguments. We might have some questions regarding factual statements, if any. And then Franchise Tax Board, you'll have 5 or 10 minutes. We'll come back to appellant for the final 5 minutes. And that's all the preliminary matters I had. Let me ask if there's any questions from appellant before we go on the record.
No.
Okay. And Franchise Tax Board, any questions?
No.
All right. And if my panel is ready? Yep. And the stenographer is ready? All right. We will now go on the record. This is the appeal of Carl L. Giordano. It's OTA case number 18053180. It is 10 a.m. on February 25th, 2020, here in beautiful Sacramento, California. I'm the lead AOJ for this hearing, John Johnston. With me today, Judge Brown. Good morning, Judge Brown.
Good morning.
And good morning as well to Judge Ewing.
Good morning.
Thank you. Let me have the parties introduce themselves for the record, starting with appellant.
Carl Giordano.
Thank you. And is Mr. Giordano okay if we address you that way?
Sure.
Okay. And Franchise Tax Board?
Joel Smith.
Thank you. And Mr. Giordano, I know you had the Tax Appeals Assistance Program, or TAP, T-A-A-P, representing you on appeal. They did not respond to the hearing notice or appear on your behalf at the pre-hearing conferences, so just to be clear, they're not representing you today. Is that correct?
Apparently not.
Okay, thank you. I want to remind everybody that OTA, the Office of Tax Appeals, is an independent agency. We have no ex-parte communications with Franchise Tax Board or appellant regarding this matter. Everything that we're going to base our decision on is what's been presented by the parties through briefing and today, and everything that we've received has been shared with both parties. Furthermore, each administrative law judge at OTA is bound by the Code of Judicial Ethics, and we're bound to be independent and impartial. We have read the briefs and examined the submitted exhibits, and we are looking forward to your testimony and arguments today. We appreciate also that taking many steps to get to this point, and thank the parties for their efforts this far. The issue on appeal is whether the demand penalty is properly imposed, and if so, whether appellant has shown reasonable cause for the failure to respond to the demand penalty. Appellant has provided Exhibits 1 and 2. Franchise Tax Board has provided Exhibits A through I. The parties have stated they have no objections to the exhibits, and those are therefore admitted as evidence into the record. With that, we are ready to begin with the parties' presentations. We will start with Appellant. If you're ready, I can swear you in. All right, please stand and raise your hand. Do you swear or affirm to tell the truth, the whole truth, and nothing but the truth?
I do.
Thank you. And you'll have up to 10 minutes. You can begin whenever you're ready.
All right. For housekeeping, I just want to confirm that the board is in fact employed by the state of California. Is that correct?
Office Tax Appeals is an agency within the state of California, correct?
So you are California employees,
Correct.
state of California employees, and you investigate the state of California. So you're investigating the party. You work for the party involved in this,
We don't work for the Franchise Tax Board, no.
but you work for the state of California.
That is correct.
Franchise Tax Board is the state of California, is it not?
They also are an agency under the state of California, correct?
Mine is really short and sweet. I really don't have much to present other than on or about March 1st of 16, I received a notice from Franchise Tax Board indicating that a demand notice, I guess you might say, and I returned that around March 7th asking for a 6-month extension. During that time period, I never received any other correspondence from the Franchise Tax Board, and I, in fact, did complete my return within the 6-month time frame. After I got that, after my return was submitted, then I received a letter from them stating that I owed them penalties in the amount of $608 because I did not file, or that I ignored, is what I think they mentioned. I ignored their demand letter. And my defense would be that I sent in an extension around March 7th asking for the 6-month time extension, and I never received any other correspondence from them saying yes or no. I assumed it was a yes because I never received anything else saying no, we're not allowing you the 6 months time extension. And then I received, like I said, the notice of demand for penalties, and then I appealed that through the appeals board, you might say. So I don't really have any other, other than what's in the 1 and 2 for exhibits, I don't have anything else to submit.
Thank you. Franchise Tax Board, do you have any questions for Appellant?
No.
Okay. And any questions from the panel? Judge Ewing?
No.
Okay. And Judge Brown?
No.
All right, thank you. Franchise Tax Board, then you'll have up to 10 minutes. You can begin whenever you're ready.
Thank you. Good morning. There are two parts to this appeals issue regarding the imposition of the demand penalty. First is whether a respondent properly imposed the demand penalty for the 2014 tax year. As I will explain, under California Code of Regulations, Title 18, Section 19133, imposition of the demand penalty is proper. Second is whether appellant has established reasonable cause to abate the demand penalty. The record shows appellant has not established reasonable cause. The facts are straightforward, as appellant shared. When respondent did not receive a timely 2014 tax return from appellant, respondent issued a demand for tax return. When respondent failed to receive a response, respondent issued a notice of proposed assessment imposing the demand penalty. Thereafter, appellant filed his 2014 tax return. Respondent accepted the return and adjusted the demand penalty accordingly. Respondent imposed the demand penalty under authority granted by Revenue and Taxation Code Section 19133. This section gives respondent discretionary authority to impose the demand penalty. As a result of this discretion, respondent adopted Regulation Section 19133 in 2004. Under Regulation Section 19133 Subdivision D, the demand penalty for appellant's 2014 tax year is proper because respondent issued a prior notice of proposed assessment to appellant for the 2013 tax year after issuing a request for tax return. The rules of statutory construction govern the interpretation of regulations. California courts have held that the fundamental objective when interpreting a regulation is to determine the intent of the agency adopting the regulation. To start, courts look to the plain meaning of the language to determine the agency's intent. Under Butts v. Board of Trustees, which cites to Code of Civil Procedure Section 1858, when interpreting a regulation, courts must first give meaning to every word and phrase in the regulation. Courts must read the regulation as a whole, and courts cannot omit what has been inserted into the regulation. After considering the entire regulation, if the plain meaning is ambiguous or inconsistent, California courts give great deference to the interpretation of the regulation by the adopting agency. Under Yamaha v. Board of Equalization, a California Supreme Court decision, California courts defer to the agency's expertise when it touches on policy issues within the agency's purview and when the agency has shown consistent enforcement of the regulation. So now we need to apply the rules of statutory construction to Regulation Section 19133. The plain language in subdivisions B and D of the regulation creates ambiguity in the regulation, meaning courts cannot simply look at the plain meaning of the language. Respondent is not aware of any California authority that suggests subdivision D should be ignored if it is inconsistent with subdivision B. In previous demand penalty opinions, the Office of Tax Appeals has quoted Cook v. Commissioner, a Seventh Circuit case which is not mandatory California authority, to support the assertion that subdivision D of the regulation should be ignored. Cook v. Commissioner held it was proper to consider an example in a federal Treasury regulation that was consistent with the other parts of the regulation. Cook v. Commissioner did not consider the situation here today where two parts of the same regulation are inconsistent. Therefore, in accordance with California law, subdivision D should not be ignored, and deference should be given to respondents' long-standing interpretation of the regulation. As stated, Revenue and Taxation Code Section 19133 grants respondent discretionary authority to impose a demand penalty. In order to provide uniform exercise of that discretion, respondent adopted Regulation Section 19133 more than 15 years ago to provide clear direction to California taxpayers. Respondent adopted the regulation with the intent to codify respondents' demand penalty policy to penalize recent repeat non-filers. In addition, respondent adopted Regulation Section 19133 after substantial analysis on the imposition of the demand penalty with input from the three-member Franchise Tax Board. Respondent's interpretation of the regulation provides certainty to taxpayers. That is, respondent will impose the demand penalty if it issued a notice of proposed assessment to the taxpayer for one of the immediately preceding 4 tax years. An alternative interpretation that ignores subdivision D of the regulation and ignores respondent's intent is not consistent with California law, creates unnecessary confusion, and puts taxpayers at a disadvantage if their distant filing history can expose them to the demand penalty. Respondent's interpretation of Regulation Section 19133 addresses an area of the agency's expertise where the agency has shown consistent enforcement of the regulation for more than 15 years, and it touches on policy issues within the agency's purview. Therefore, under Yamaha v. Board of Equalization, deference should be given to respondent's interpretation. Respondent properly imposed the demand penalty for the 2014 tax year. As for abatement of the demand penalty, under Revenue and Taxation Code Section 19133, respondent's imposition of the demand penalty is presumed proper unless appellant is able to show that his failure to timely reply to the demand for tax return was due to reasonable cause and not due to willful neglect. As stated in the appeal of Tao Shia, a precedential OTA opinion, the appellant must provide credible and competent evidence to support a claim of reasonable cause. Further, unsupported assertions do not establish reasonable cause. Here, appellant has not provided any credible and competent evidence to support abatement of the demand penalty. Appellant has only made an unsupported assertion that he requested a 6-month extension. It is respondent's normal course of business when a taxpayer requests an extension on a demand to issue a letter to the taxpayer informing them of the extension. There's no record of an extension being granted or an extension being requested from appellant for this matter. For appellant's 2015 tax year, which is not the tax year at issue, appellant was granted an extension to respond to the demand. Again, there was no evidence of that for the 2014 tax year. So as such, based on California law and evidence in the record, respondent requests you sustain its position. I can answer any questions you might have.
And we'll turn to appellant. We have afforded 5 minutes for you if you have anything that you would like to reply or add at this point.
Yeah, I'd just like to reply that I heard a lot of, seemed like lawyer talk, but I still haven't seen any proof that I ignored their demand. Where is their proof? I mean, is it possible that the letter that I sent off was lost in the mail? Was it possible that it was lost by one of the employees of the Franchise Tax Board? Also, I don't understand why I just can't be assessed a late fee. What did the state of California, how were they damaged by using my money free for a 2-year period? What did they suffer? What damage did they suffer having my money for 2 years free? And why can't I be afforded the same luxury that the state of California is afforded, where they say they just have to send the letter to the last known address? I've been at the same residence for 20 years, yet they've used 3 different addresses to correspond with me. And lastly, I would just like to know who else other than the state of California or a government agency would be able to get away with something like this. If I was running a private business and I was doing something similar to this, I don't think I'd be in business long. In other words, a 25% penalty over, like I said earlier, they had free use of my money for 2 years. How were they damaged by them not receiving my tax return in a timely manner? They had my money for 2 years free. I don't have any other questions other than that.
All right, thank you. Let me turn to my panel members to see if they have any questions for the parties. I'll start with Judge Ewing.
I do not.
All right, thank you. And Judge Brown?
I do not.
All right. Mr. Giordano, I believe from your briefs that were provided, the assertion is that you received the return addressed envelope from Franchise Tax Board with that demand, and you used that to send back the request for the extension. Is that correct?
That's right.
And you didn't happen to keep a copy of the extension request? Understandable. Okay, thank you.
What as the state mentioned earlier, I've had in the past, he mentioned prior to the next tax year in 15, I did the same thing. So.
Right, thank you. And Franchise Tax Board, what is the situation? What happens when there's potentially a letter that gets lost in the mail or lost at Franchise Tax Board? What's the general laws you understand regarding that?
Well, the general law, as I explained, was that that there needs to be credible and competent evidence. Generally, that's considered a certified mail receipt in this particular situation. We've also got if a phone call is made, that's documented, and if something is received in the mail, that's also documented. There's nothing in our files to suggest that anything was filed. So the general legal principle is that it's the taxpayer's burden to establish reasonable cause.
I might add, though, that he mentioned that there's nothing certified mail, but none of the letters they sent me were ever certified either.
Thank you. And going to the regulation, if we can, just for a minute. I know you mentioned that the purpose of the regulation was to address recent repeat non-filers. What do you mean by recent? Is that defined in any of the legislative language or in the statute or regulation itself?
No, that's just a term that I've used. That's the intent. It's not to. It's to look back at the immediately preceding 4 tax years and to determine if a request or demand was issued for one of those 4 tax years, and that's how it's been applied for more than 15 years, and that's how the system, the filing system works. If it's to be interpreted another way. It doesn't fit with how the filing enforcement system works. If the prior year, say in 2013, if that NPA doesn't meet the regulation standard, then the FTB would never be able to impose a demand penalty if someone were to fail to file in the prior year, because the FTB waits until a return is not filed to reach out to the taxpayer to inquire about a filed return. So that's why it's applicable to the 4 tax years, not calendar years looking back. And by extension, if it were to be considered based on when the NPA is issued, not the tax year that it's issued for, then a taxpayer's failure to file 7, 8, 9 years into the past could expose them to the demand penalty under that reading, and that is not at all what the demand penalty regulation was adopted to address.
And the regulation, so what is the intent behind allowing sort of having to have this prior failure to respond to a request or demand that resulted in an NPA? What's the purpose of allowing sort of a freebie, if you could use that term, before then imposing demand penalty on the second infraction? Does that benefit to the taxpayer, or what's the purpose of that?
Right, so before the regulation, the regulation just says the FTB may impose the demand penalty. And so it's a discretionary statute. FTB has discretionary authority to do it. And so the regulation was adopted to make that discretion uniform and applicable to all individual taxpayers. So is it taxpayer friendly? Yes, because the statute could give FTB authority to impose a demand penalty right away. And the decision was made to give taxpayers the one freebie, as you called it, within the previous 4 tax years to impose the demand penalty. So the reason for the regulation is to just create uniform application of the demand penalty for all individual taxpayers.
Was the purpose of the regulation to provide sort of a warning or a notice to the taxpayers before being hit with the penalty, or is it merely to not give the penalty to individuals who had made one mistake and instead try to target repeat non-filers?
Meaning that we would never send a request or demand, we just impose the penalty right away?
Yeah, maybe there's a false either or. Is there any intent in the regulation to give taxpayers a warning that a repeat failure to respond to a demand could result in a penalty? Is that part of the intent of the regulation or not?
I suppose that it could be. I mean, the intent is to uniformly apply the demand penalty to individual taxpayers. And by letting a taxpayer know, I mean, that's just the process of the penalty, as far as you got a request or a demand and you didn't respond to it for one of the 4 previous tax years. So that exposes you to the penalty. You still get the request or demand you get the demand for the following year to give you the heads up that it is a possible penalty and that you need to respond accordingly. I hope that answers the question. I'm a little...
I believe so, yeah. I guess one question I have is just, you mentioned how, if you read it the other way, that the NPA had to be issued during one of the preceding years to the tax year at issue. You come in a situation where the tax year could be 7 years prior, for example. And my question is, when you're looking at, say, 2013 and 2014, you have a situation where, for example, in this appeal, the request for the 2013 tax return didn't come until after the filing due date for the 2014 tax year. And my question is, if that sort of request, non-response, NPA for 2013 that came out in June 2015, if that was supposed to act as sort of a notice to the taxpayer that you need to respond to these requests, otherwise you could get hit with the penalty, is it meeting that purpose if it's coming out after sort of the failure has already happened for the second year?
Right, and I mean, it's not that when you're notified, the penalty is automatically imposed. There is the the notice that, hey, if you don't respond, this penalty will be imposed.
The demand itself for the second year would be notice that the penalty is going to be imposed.
Correct. It doesn't mean that it will be imposed.
Okay. And just last question, and I appreciate you, Mr. Giordano, for being patient during this sort of lawyer speak. You mentioned that the inconsistency between subsections or divisions B and D. So in B, it does say during the 4-year period rather than for that 4-year period. Do you have any thoughts or explanations as to why during was used there rather than for?
No, I do not have any thoughts. I know that how it's been applied for more than 15 years.
Okay, thank you.
How I've explained.
Right. And
which is consistent with subdivision D.
Subdivision D is an example, correct? Provides a set of a fact pattern.
Yes, subdivision D is part of the regulation. It is an example.
Does subdivision D, particularly that example, does it provide sort of 4 corners of when the penalty is going to be imposed, or is it simply one fact pattern?
It provides an example of tax years 1999 and 2001. The fact pattern that it outlines would not result in the demand penalty under subdivision B. So that's where the ambiguity exists and where the next step in statutory construction needs to be taken.
Thank you. Let me circle back if there's any more questions. Judge Ewing?
Yeah, I do have one question for the Franchise Tax Board. I understand that the letter that the appellant sent or says he sent to you requesting additional time to file the return. You did not receive that letter. The appellant does not have a copy of the letter, but I believe it's your position that regardless if you had received that letter requesting for additional time to file the return, that would not have sufficed for purposes of the penalty. Is that correct?
Taxpayers can ask for an extension, and if we get that extension, it can be over the phone, which is explained on the demand itself, or written, and then the standard practice is, even if it's over the phone or written, the respondent issues a letter saying we received your request has been granted, you must file a return by this date.
Judge Brown?
I do not have questions.
All right. So with that, I believe we have the admitted evidence from the record. We have your arguments and your testimony today. Is there any final questions from appellant?
No.
Okay. And any final questions from Franchise Tax Board?
No.
All right. Thank you. I wish to thank both parties again for being here today and presenting your appeal. The record is now closed. This concludes the hearing on this appeal. The parties should expect our written decision no later than 100 days from today. With that, we are now off the record, and this concludes today's Office of Tax Appeals hearings. Thank you.
Thank you.